Okay, so let's start with the presentation. Well, when we started preparation for this topic or for this presentation, we stopped with the name, the legal aspects of diversity, inclusion, equity, etc. It's very general definition. When we are talking about legal aspects, there are like several thousand questions that can raise your concerns. For example, I think that all of you that are sitting here have different questions or different topics you want to discuss. So from our part, it will be just basic presentation about topics that we deal with in accordance with the diversity and inclusion. And then I think that the most interesting part will also come with the discussion and with your questions. So from our side, there will be some points or some key topics that we can see in this part of law, or it's not some specific area of law. And then we can discuss what are your concerns, what are your questions, etc. So let's start with that. As I am a lawyer that mainly deal with privacy, with GDPR, and with personal data, I think that one of the main topic also in the area of diversity and inclusion is how to work with personal data. What are the rules about personal data? Whether there are some specifics, how you can deal with them. And I choose topic that's regarded to inclusion surveys or some information that you can gather about your employees, for example, and if those information contains personal data, how to deal with them, what are the rules set it in the Czech law or in the European law. I don't want to go into some theoretical speech about what is GDPR, that there is a regulation about GDPR, etc. I think that maybe all of you in your life had some kind of learning or some learning about GDPR. So I will step into the concrete information that I think are important for the diversity, and those are personal data, because the main information that I want to give you regarding GDPR is that a lot of people working with surveys, with information about employees, don't or forget what personal data is, or what is the definition of personal data, because in GDPR we have definition that personal data is an information that is relating to an identified or identifiable natural person, which is like really nice definition, but no one like really know what's to take from this definition. So do not forget that when you are working with any information that you will pass to any employee, or you have it for any employee somewhere written, or you work with those information, all of those information are personal data. You know, those typical examples like name, surname, address, birth number, all of them are personal data. But anything you can mention or you can think about is personal data if you take those personal data and work, or take those information and work with them about some person. I will give you some example, which is maybe also from the LGBT part of processing of personal data, and that's a Grindr application, which is something like Tinder application. Maybe you know it. And there was one ruling from Norwegian supervisory authority saying that on the Grindr application was fined about, I don't know, 6 or 7 million euros for not protecting personal data and not getting correct privacy policies, etc. And one of the findings of the supervisory authority was that the only information that you are registered on the Grindr application is like sensitive information that can lead to information about some sexual orientation about those people. So think about it, that any information in some context may be personal data, and always find the context where you gather those information. As I mentioned, there is also one specific category of personal data, and it's called sensitive personal data, or special categories of personal data according to GDPR. And those are really largely connected with the diversity and inclusion. It can include information about sexual orientation, sex life, or some biometric data, health data, etc. And all of those information have very special rules how to work with them under GDPR. When we look at it in more specific way, generally, it's prohibited to process personal data about sexual orientation, sex life, health data, and other that are stipulated in Article 9 in the GDPR. However, there are some exemptions for their processing. If you want to process them, you need to find this exemption. For example, the first and the most common exemption is that you have explicit consent of the person, of the data subject, or when it's necessary for the carrying the obligations in the employment or social security law, or if they are publicly available from the data subject, or it's in some public interest. There are, I think, 9 or 10 exemptions in the GDPR under which you can process those special categories of personal data. And this also you have to take into consideration, for example, when you dealing with surveys or with some inclusion surveys, because in most times you need explicit consent from the people or from the employees when you want to work with their personal data. And as I mentioned, the definition of personal data is very broad. So any information that can lead to any of the kind of the information that I mentioned may be considered as personal data. So it's very important to mention that. However, the GDPR is not the only regulation or the only law that we have to take into consideration when we are talking about this kind of processing, because then we have specific rules in labor law or labor code, more specifically in Article 316 of the labor code, where our information that you shall not ask the employees never, like sexual orientation, origin, trade union membership, membership in political parties. However, there are some strict exemptions when you can ask them, but they are very, very, very strict. And then there are some categories of data that you can ask for with specific regime. For example, information on pregnancy, family property status, criminal records. When the reason or when the work nature that the employee shall do is and it's reasonable for the work nature to gather those information, then you can do it. However, you need to assess it, you need to like write it down somewhere, those assessments, and to be able to provide it, for example, when there will be some checks by supervisory authorities to have it. Then there are a lot of other laws that can be used. It depends on the data that you want to gather. For example, zákon o zaměstnanosti, which may also stipulate some specific rules what can you take from employees for personal data. However, these two are the main topic. So to sum up this information, if you want to work with personal data about employees, for example, in case of inclusion surveys or some diversity surveys, or for any other reason, you need to always look in the GDPR whether you are working with special categories of personal data that I mentioned, also whether it's not prohibited by labor code, and whether there are some other laws or codes that you need to abide and it may prohibit the processing of those data. And you need to always take these two topics into consideration. So when you are working with inclusion surveys, the first thing, as I mentioned, when you are working with sensitive personal data about sexual orientation, sex life, or something like that, just make this service voluntary, because there will be no, like from my point of view right now in the Czech Republic, when we are looking at it from the Czech perspective, there will be no other exemptions that you can use under the GDPR and Article 9 when using special categories of personal data other than consent of the employee. So when you want to work with personal data, you need their consent. However, it's feasible, or when it's feasible, then collect data anonymously, but be aware, being anonymous is really hard. That means when you're working with personal or with data that are not connected with the natural person, there shall be no possibility to connect those information with any of employees. For example, if you have 10 employees on, for example, in some department, there are 10 employees, all of them will fill out some survey, for example, and there will be really specific question that can lead only to the one person that is sitting in the department. For example, the number of feeds. For example, if there will be 10 men, I'm sorry for that, and the only one person will have the feed long, for example, 50 centimeters, or I don't know how it's counted, then it still will be personal data because you are able to connect those information with concrete specific natural person data subject. So be aware about what is anonymous and what's not anonymous, because it's really hard to anonymize personal data. And always follow the principle of data minimization, which means that always only gather information that are really necessary for the purpose you have. Whenever you will be working with personal data, including surveys or any other case, I prepared a checklist that will be shared also with you, what you should take into consideration from the personal data view. Always you need a purpose. You need to have answer for the question why. Why do you need those data? Why do you process? Why do you work with them? And whether it's voluntary or whether it's stipulated by some law, for example, in the future when there will be some specific rules stipulated in new acts that will be into force. Then follow the data minimization principle, always process only necessary personal data and assess what are the special categories, what are the sensitive personal data, and find exemptions for those specific special categories of personal data. Where possible, try to be anonymous. Determine the legal basis under which you will be processed those personal data. The legal basis where maybe consent, performance of contract, legal obligations. It's already stipulated in Article 6 of the GDPR what should be the legal basis. Avoid free text survey answers, for example, because it may lead that you will gather more extensive information that you need for the purpose, and then the data minimization principle will not be met. And also prepare all necessary documentation under GDPR. That means DPIA if necessary, records of processing activities, privacy policies, consent, processing agreements if required, etc. So this checklist may help you. Maybe you noticed the whole GDPR or personal data point of view is a really broad topic. I only pointed out some few information that I think may be interesting for you. However, I am looking forward for maybe discussion whether there will be some specific question about personal data view. And right now I will pass the floor to Petr, who will continue with the labor point of view. So it's yours.
Okay.
I'm sorry. Maybe we will discuss it after.
Thank you for giving me the floor. By the way of introduction, my name is Petr Glogar. I'm an attorney at law in the Sedlakova Legal law firm focused on labor law and employment. So we can talk about each letter separately because we have a DEI topic. And the first question is if DEI topic is favorable for both the employer and employee, and our answer is definitely yes, it is. Because as you can see, and maybe if you know from your own experience, only diversification or very variable working environment may increase the working productivity and flexibility within your company. And definitely if you have a mix of people with different race, sexual orientation, age, and working experience, or with health disabilities, this will create I think a very healthy working environment, and it may at the end of the day reduce any complaints or discrimination issues. And you will see, or you see that this can definitely from the viewpoint of new candidates or your customers, this can be let's say favorable for both your customers and your company or candidates which will be hired by your company. So while letter D and E are fully recognized by the Czech labor law, letter I as inclusion is more or less about your corporate responsibility, about your let's say, policies which are focused on people who are not caught by the net of the law, who are out of the HR perspective, and so we can now focus more on the D letter, which is from I believe from our experience very important for your HR practice. And as I can see, we have here a lot of big names such as KBC, Tesco, Deloitte, and I believe that from our experience, diversity as a way how to deal with the daily HR agenda. So maybe I will not explain to you, and maybe it is wasting of time to explain what's the diversity within the workplace. Maybe one comment from my side and from the labor law perspective, diversity is obligatory because within the Employment Act there is a written within the section 81 that the employer having more than 25 employees is obliged to employ certain amount of people with health disabilities. In other words, you should have a certain amount of disabled people, or if it's not possible due to work restriction, working environment, or for whatever, for any other reasons, you should pay a fee to public funds, or you should buy products from the special licensed companies which employ disabled people. So diversity is fully recognized and is obligatory to have it within your companies, and I believe that you are meeting this requirement given by the Czech law. I will move forward to let's say another topic which relates to gender. As you know, and still in many countries applicable, in the Czech Republic we still have a male and female gender, and in another simple words, it is decisive what is written within your personal documents. If you have a male within your ID, you are male, irrespective of your feelings, and vice versa. So what can you do for gender which doesn't fall under male or female? We have people with specific needs and specific feelings which go beyond the male and female gender, and definitely the minimum you can apply within your company is to let's say draft documentation in a manner that it will recognize the third gender or people with specific needs, which cannot be recognized as a male or female feelings or gender. So as you can see, there are no let's say significant costs related to specific questionnaires, specific language within your job offers, and or there are no costs regarding using neutral titles. Maybe there are some expenses related to bathrooms for third gender. But as you can see from our experience, everything should be done more or less free of charge for them, and it will be definitely favorable both for you and the candidate or your employee who is not male or female. So maybe what's the best practice from the labor law perspective regarding discrimination. I saw one question regarding discrimination before this presentation, and I tried to capture some examples what is discriminatory and what isn't discriminatory based on the best practice. So as you can see, discriminatory is not treating females or pregnant women in case of heavy work, or discrimination are not restrictions in respect of employees with age limits. I mean juvenile employees, etc. So what can you do for specific groups of employees, seniors, employees with health limitations, etc.? You can have specific benefits, even monetary or non-monetary, for those who are protected by the law, and this is not discrimination. So if you apply I don't know, some benefits, for example, multi-sports card or any other benefits which are focused on a weak group of employees, then this is not discriminatory. So what can be discrimination on the other side is direct discrimination, definitely, but I believe that currently no one applies direct discrimination within job offers or during the employment relationship. However, we can definitely identify indirect discrimination, which is not recognized even by the management or by the HR, and this is discrimination which is not obvious. This is discrimination which follows from the policies or contractual clauses. And it is not intentional discrimination. It is unintentional discrimination, but at the end of the day, you can see that, for example, attendance bonus, which is broadly applicable within the Czech companies, can be in many cases can bring or can have in many cases signs of discrimination, because if you grant bonus or premiums for those who has fully attendance within their shifts during a month, so it is discrimination, indirect discrimination of females or people above 50 or 55, because it is objectively proved that this group of employees cannot have fully attendance during a month because of their status. Females must take care of their child. Seniors or elderly people or elderly employees often visit a practitioner or doctor, so it is not possible for these people to meet the criteria, and as you can see, it is indirect discrimination. Another discrimination can be bonus or premium granted only for full-time workers. If you have a full-time worker and you have a policy that everyone with 40 hours per week is entitled under certain criteria to receive a bonus or premium, then it can be indirect discrimination, because someone with part-time, who is mostly women or maybe a man taking care of a child alone, then it is indirect discrimination because it is proved that these protected groups of employees have part-time engagement with your company. So if you stress out the criteria only for full-time workers, it is not possible to reach the condition and the criteria for bonus. So I will move forward to equality. As you know, current labor code recognize the same principle as the entire European Union, that the same job or job of the same value deserve the same remuneration. And as you can see, the condition of sexual identity, sexual orientation, and any other conditions are not criteria. Only criteria you have, it is same job or job of the same value. Job of the same value is a bit tricky, because if you do not have two positions within your company, you can still have one position which is different to another one, but if the another one has a different name but it has a same value, it can be compared. So it is a bit tricky, and Czech case law works with these definitions within their decisions or court decisions. So please pay attention to definition of the job or job of the same value. So as you can see, third gender is not a question or condition, and everybody who works under the same conditions is entitled to receive the same remuneration as his or her colleague. Maybe from our perspective is a topic, the EU Transparency Pay Directive, which is let's say closely relates to equality topic. This is because EU Transparency Pay Directive is, let's say, activity of the European Parliament, which is focused on a pay gap between men and women. And definitely this will bring to the Czech legal environment a lot of questions, and this will bring a lot of obligations which will be imposed both on the employers and some of them to employees, but employees will receive a lot of favorable provisions and rights to be applicable towards the employee. EU Transparency Pay Directive will be implemented within next year, and this will be in a form of amendment to Labor Code and maybe another legal acts. And as you can see, this will bring a revolution into the Czech HR environment, because definitely candidates and employees will receive a lot of rights, and some of these rights are not favorable for the employer, because employers will have obligations, which is quite clear. And as you can see, candidates must be familiarized with their remuneration or the range of the remuneration even before the first interview in the form of the public job offer, or our opinion is that it could be also in the form of a separate individual email. So the employer in the best scenario will not be let's say forced to publish the range of remuneration within the certain position.
Sorry for interrupting. I just need to say that we have 2 more minutes for the presentation, so that we then have a chance to ask questions.
Okay, I will speed it up. And I will move forward to another slide, which is Q&A. Okay, so this is the last slide from my presentation. As you can see, and from my perspective, the EU Transparency Pay Directive is one of the most important things which will happen in upcoming months and years. So I will be happy to answer your questions in this respect. So thank you for your attention.